Were it not for Mr. Kirgovich and Mr. Haynes, we would be full house, but we aren't. And from the prosecution, I noticed Mr. McCloskey, Mr. Tyre, and Mr. Van der Puy. Is there anyone else? No. All right. I take it there are no preliminaries. We might come back to you on a couple of points later. We need to finish with the documents, the defense team for Popović in relation to the previous witness, Mr. Zivanovic.
Good morning, Your Honor. We provided a list of our documents and distributed to the all teams and the prosecution.
Thank you. And are there any objections, Mr. McCloskey?
Not right now, Mr. President. A few of them were not dealt with the witness, but we've spoken to Mr. Zivanovic, and we all think they are part of his report. If there's a problem there, we'll let you know, but I don't think there should be.
I think you dealt with that last time. Basically, you said that they referred to the witness's report or something like that, and in view of that, you would not be objecting? Or?
That was the Nikolic team.
I see. All right.
And I think the situation's the same, but the prosecution has one additional document to offer, and that is 1D1302. That's the Masayevsky report that Mr. Zivanovic said he was going to offer at the time. I've spoken to him. He's changed his mind, but given that it was used and why it was used and how it was used, I would offer that report into evidence.
Yes, Mr. Joss.
Well, I think one of the reasons my learned friend Mr. Zivanovic didn't use it is I made it clear to him that I would oppose it if he sought to put it in. I haven't had that conversation with Mr. McCloskey. He wasn't aware of it. I take the same stance. 2 paragraphs of a very long report was referred to. Those 2 paragraphs were read out. They could be exhibited separately, and I would take no objection to that. But why the rest of the report should go in, I really don't know.
Were the 2 paragraphs part of the conclusions?
Yes, Your Honor. But I used just one.
Yeah, but they were part of the conclusions, in other words. Yes, Mr. One moment, Mr. McCloskey. Ms. Popović.
Your Honor, I fully support what Mr. Joss just said, but I would like to add that this is a very long document, and it deals with 93, the year 93, which is not really relevant in this trial. Furthermore, I believe that the trial chamber has a practice when there are only 2 paragraphs that were presented, and when these paragraphs have already been read out during the hearing, there's no need to tender the full document into evidence.
Thank you. Yes, Mr. McCloskey.
1993 is of significant relevance to this case. The history of this situation is vitally important to understand. We have chosen to target our indictment to 1995, but that has not kept anyone from dealing in depth with 1993. This witness dealt in depth with 1992, 1993, and we heard document after document, statement after statement of the situation with Nasser Orich in the 28th Division. And then the Masayevsky report is used for one particular conclusion. So I bring the Masayevsky report in because the defense used it for a conclusion in a report and to rebut much of what the witness said. The defense brings up these sorts of things at their peril. And you can't just take one little piece and then expect that that little piece is going to sit by itself. And the paragraph above their piece was also obviously very important, but those 2 important conclusions are not fully in context unless you see the whole report.
All right, thank you. Yes, Mr. Joss.
There are obviously 8 parties to this case, 7 accused, and perhaps the Chamber would bear that in mind in relation to what Mr. McCloskey has just said.
Thank you. Otherwise, yes,
I
Mr.
apologize,
Valazarevic.
just to add that Borovchany defense would like to join the objection that my learned colleague Mr. Jossi has raised, and also what Madame Fauveau has just said. It was in the line of practice of this trial chamber, so only what was used during cross-examination of the witness should enter into evidence, not the whole document.
Yes, thank you.
We join as well, Mr. President. Good morning.
Thank you. Even that the 1993 events are not relevant?
No, Your Honor, and I watched that very carefully, and I'm happy that my learned friend was open and honest with the court regarding that. But no, I do not share. I agree with my learned friend that 1993 is relevant and it is probative, as the court knows from our evidence, and I'm glad that he agrees with us.
Thank you. Our decision is as follows. We are not yet in a position to know precisely whether, for our purposes, when we come to deliberate, having in the records just that one page which was made use of would suffice or not. It may well be the case that in order to understand better that conclusion, we might need to refer to the rest of the report or other parts of that report. So our decision is, for the time being, we are admitting that page only, with the caveat that if we feel the need to have the whole report, UN report, admitted, then we will ask for it. And of course, we will let you know that we have done so. Yes, Mr. McCloskey.
Thank you, Mr. President. I am sorry I was not more prepared on that issue. I thought Mr. Jovanovic was going to offer it into evidence. It is a 20-page report only, and would the court accept a brief argument from the prosecution on that? And when I take a closer look at that last page, maybe there is a way to narrow it down to the chapter or whatever, but it's only a 20-page report.
Okay, thank you. Yes, Miss. Let's not lose more time on this, please. Yes.
Monsieur le Président.
Your Honor, I would like to correct the transcript. On page 2, last line, line 25, or page 3, first line. 1993 was not, says that 1993 was not relevant. It's not exactly what I said. I said that 1993 is not the topic of this trial, which is a bit different.
Thank you. That's important. So all these documents of the Popović defense team are admitted. I take it there are no objections from any of the other defense teams. it seems that quite a number of them have not yet been translated, and therefore those will remain marked for identification only until they are translated to the satisfaction of the parties, and then the upgrade would be automatic. With regard to the document that the prosecution tendered, I think we've been clear. It's only that page which is being received for the time being. The rest will decide if we need afterwards. Yes, Mr. McCloskey.
I'm told that's page 18
Page
from that report.
Okay, page 18. Thank you. So, we have now finished the first defense case, and we are starting with the second today. In the meantime, before I give the floor to Mr. Beara, there is a motion from the Nikolic defense team, which I would kindly ask you to attend to and come back to us at your earliest, please, with your response.
Yes, Mr. President, that will be done with all the rest.
Okay, thank you. Mr. Ostojic, you have 60 minutes.
Thank you, Mr. President, and your honors. May it please the court, my learned friends from both sides of the table, Mr. Beara and other accused. Your honors, it is certainly a privilege after 2 years to be able to have an opportunity again to address you, and once again, on behalf of the Beara defense, we thank you for that opportunity. We've heard a lot of evidence, but I think we have not heard a sufficient amount of evidence. My preliminary remarks are that proof that crimes have occurred or that they have been committed is not sufficient to sustain a conviction of an individual. Criminal proceedings require much more, and they require that the prosecution establish beyond a reasonable doubt that the accused is responsible for crimes before a conviction can be entered. I raise that because the issue of burden of proof comes to mind, and we must remind ourselves once again that we, the defense, have no burden whatsoever to prove any element or any facts in this case. The burden of proof, as decided by the decisional authority in this tribunal, is that it remains with the prosecution throughout the trial, even the phase of the defense case. That burden, as heavy as it may be, which is to prove beyond a reasonable doubt, is a cardinal principle of criminal law. The burden never shifts to the accused or the defense, and by choosing to present evidence during this phase of the proceedings, we are not suggesting or intimating that we are accepting or shifting that burden to ourselves, but rather, it is a further step in the process and the interest of justice to assist this honorable trial chamber to see the areas and issues which have not been proven beyond a reasonable doubt, and to show the trial chamber where certain reasonable inferences may be drawn in favor of the accused. The first issue I'd like to discuss and establish with the evidence that we'll bring is the issue between evacuation and deportation or forcible transfer. In paragraph 78 of the second amended consolidated indictment, the prosecution alleges against Mr. Beara that he planned, organized, and assisted in the gathering together, detaining, and transporting of Muslim men. They further allege that he supervised, facilitated, and oversaw the men from Popović that they be placed in detention centers in the Zvornik area. What evidence do we expect to bring forth and why? Initially, I must tell the court that one of our witnesses, although she is a joint witness, is a demographer, Dr. Svetlana Radovanović. She will hopefully come during our case, as we've identified her in the list of witnesses for July, to assist the trial chamber and to show us the defects and the flaws in the OTP's demographic analysis through experts which they have brought. We also believe that through her testimony, she will further reveal not only the flaws in that analysis, but the flaws used in the methodology and the conclusions reached by the demographic experts that the OTP provided to the court. We believe that her evidence will assist us in giving us more accurately the number of citizens and the population that existed in Srebrenica at that critical time. In keeping things in context, I think it's important to know whether those citizens in Srebrenica were themselves refugees and whether or not the government of BiH at any time, and specifically in 1993, expressly, as we've seen from time to time, prohibited them from exiting Srebrenica. Their willingness or voluntariness to leave will be an issue that will be discussed at some length. The movement or removal of the civilians in cooperation with Dutchbat was an evacuation, in our opinion, and as a result, a military necessity, and was not either deportation or forcible transfer. When we see the allegations in paragraph 78 of this second amended consolidated indictment, we look again at the words that they've alleged of planned, organized, and assisted. Although I must say that I believe the OTP evidence is not only doubtful, it doesn't exist in that regard with respect to Mr. Beara. A key focus for us, and I think this tribunal, should be the whereabouts of Mr. Beara during these critical time periods. We know several things that the OTP did during their investigation and during the presentation of their evidence, as well as through witnesses that they brought forth here at trial. And they acknowledge that they have no evidence whatsoever of Ljubiša Beara's whereabouts from July 16th through July 31st, 1995. And I believe that on January of this year, Mr. Butler plainly and reasonably said so. In addition, the OTP, when it comes to Mr. Beara, although they make these vast allegations, have no evidence whatsoever as to his whereabouts from July 1st through July 11th, inclusive, 1995. Given that, when we look at the allegations, there is no such evidence with respect to planning, organizing, or assisting. The evidence was not brought forth, and once again, it is not our burden to share with the court where the whereabouts of Mr. Beara was, but there should be enough reasonable doubt and lack of evidence to acquit simply by the evidence that they brought forth and or lack thereof. Nevertheless, in the interest of justice and in the spirit of having this court have evidence that we believe is probative and relevant, we bring forth evidence, and again, although not our duty and certainly not our burden, to show, reveal, and expose the weaknesses in the OTP's theory. Evidence will be called and has been heard that the VRS at that time was divided into 6 geographical-based corps in a very vast territory. The 1st Krajina Corps, the 2nd Krajina Corps, the Sarajevo-Romania Corps, the Herzegovina Corps, the East Bosnia Corps, as well as, from what we know from this trial, the Drina Corps. We asked the question, with the VRS or any military and its main staff, despite the spring 1995 offensive in the Krajina areas and in the Bihać area, simply ignore or fail to send any of its staff officers to those regions during July 1995? We know briefly the answer to that question because the Office of the Prosecutor brought one witness, Manilo Milovanovic, who was the Chief of Staff, and he states that he was on the other front, namely in the Bihać area or in the East Bosnia Corps. We have evidence, and we hope to present evidence, and expect to present that evidence to you, that from July 16th, for approximately 10 to 12 days, Mr. Beara went to various subordinate corps in the VRS throughout that vast territory, including the 1st Krajina Corps, the 2nd Krajina Corps, and the East Bosnia Corps. According to the prosecution, no one went to that area, even though there was a war brewing and combat engagements existing on all the fronts, both east and west, as well as north and south. It would be unrealistic to believe that the entirety of the main staff or the entirety of the VRS was concentrated in the enclave of Srebrenica and Orzepa. The evidence will be elicited from people who were at these various subordinate corps, as well as from, we expect, Mr. Ljubiša Beara's driver, Miloš Tomović. I must spend some time to discuss this witness with the court. Mr. Beara's driver was interviewed by the OTP on one occasion. We heard that briefly from their lead investigator at the time, Tomasz Blaszczyk. And he indeed informed the Office of the Prosecution of the whereabouts of Mr. Beara. He informed them that he drove Mr. Beara both to the 1st, 2nd, and 2nd Krajina Corps and the East Bosnia Corps as well. Why their investigator and why their analysts were not privy to that information will be a discussion that we will submit to this court at a later time, namely during closing arguments. They've had this information for a long time, and yet they don't utilize it, but they leave us in the dark. Similarly, the Office of the Prosecution knew or should have known that when a very frightened and scared individual with no counsel or representation and absolutely no preparation erroneously states under oath on the record that he himself was never in Belgrade on July 13th or 14th, 1995, we believe that it is the duty of the prosecution, having all the evidence that they've seized in their possession, to assist this witness to obtain a clear and honest record. Mr. Tomović, in his interview, states that he was not in Belgrade on July 13th, 1995, which is simply not true. How do we know? When assisted to refresh his recollection, and this is evidence we hope and expect that you will hear, when Mr. Tomović was assisted and his recollection refreshed, he recalled and verified that indeed he was in Belgrade on July 13th, 1995, on the order of Zdravko Tolimir. Seems simple enough, but it becomes more complicated, as I'm sure all are thinking, how was it and what was used to refresh his recollection? Again, we used evidence that was in the possession of the OTP to assist and to probe and to find the truth of the matter. We asked initially Mr. Tomović whether he kept the diary. He said no. But we found the diary, and it was not the diary of Mr. Beara or Mr. Tomović, but it was a diary of an American journalist from Phoenix, Arizona, of Serbian descent. This American journalist was also interviewed by the Office of the Prosecution. In his diary that he kept contemporaneously with the visits that he had in the Srebrenica, Belgrade, and Pale and Sarajevo areas were in July of 1995. He took down daily records of people that he met, who drove him, where they drove him from. This daily record indicates on the date of July 13th that Mr. Robert Đurđević from Phoenix, Arizona, the American journalist I referred to, was picked up by Miloš Tomović. When we inquired of Mr. Tomović if he has a recollection of that American journalist, he said he did, but he couldn't remember the date. He said, I remember picking up an American Serb from Belgrade and drove him down to Vlasenica because he was required and insisted on having a meeting with General Mladić. On the cover of this diary, and then also in the diary, as my learned friends know, this journalist in detailed fashion shows where Mr. Tomović drove him, what they observed, where the checkpoints were, and whom they encountered with. On the cover of that diary, I believe that it says, written by the journalist himself, that this diary should not be opened or disclosed for 2 to 3 years until after the war in the former Yugoslavia ceases. This diary was created at the time and kept contemporaneous with the events that have occurred, and unlike other documents, was not at any time in anybody's possession but the Office of the Prosecution, and was not altered or manipulated with. When we initially met with Mr. Tomović, we asked, do you remember anything else? Are you sure that it was the 13th? He couldn't. When we showed him the diary, although it is in English, and we translated for him and showed him the specific dates that were conspicuous on the diary, his first reaction was, oh my God. That means that I lied to the prosecution when I told them I never went to Belgrade on the 13th of July, 1995. Mr. Tomović never lied to the prosecution when he was interviewed. Mr. Tomović was scared. Mr. Tomović, as most witnesses, when they're confronted with the prosecution request to talk about events that are horrific and tragic, was certainly intimidated. Mr. Tomović made a mistake. The support to confirm that Mr. Tomović actually was in Belgrade on July 13th, 1995 is independent, and it should be accepted by this court without debate. The rest of the story, of course, deals directly with the whereabouts of Mr. Beara. Milan Stanić, our investigator, and Miloš Tomović will address those issues. Who drove with Miloš Tomović when he went to Belgrade? Who else but the person that Mr. Tomović normally and regularly drives? When we look in the context of what was happening on July 12th, the Muslim men escaped to the forest, unbeknownst to the VRS, unbeknownst to the Drina Corps. The Drina Corps find themselves in a situation where they are not engaged in battle in Srebrenica itself. The 12th negotiations were being conducted to evacuate the civilian population with Dutchbat in participation. For most parts, the event of Srebrenica occurred quickly, quietly, and it was over. Of course, Mr. Beara's birthday is the 14th of July. We've discussed that on numerous occasions, or at least in our last opening 2 years ago. Mr. Beara had a reason to go to Belgrade, and the evidence we produce will help illustrate those reasons and where he was specifically on that date. Now, we know and we understand that mere presence or absence at the scene of a crime does not render a person either culpable or innocent, especially given the overly broad and, in my opinion, rather diluted theory of joint criminal enterprise that the prosecution alleges against us. Nevertheless, we firmly believe that the whereabouts of Mr. Beara, and indeed significantly, while addressing the issues of planning, organizing, and assisting, become all the more important. I'm not sure if Mr. President is indicating for me to stop. Okay, thank you. The evidence is consistent in this regard as to Mr. Beara's whereabouts, and we've seen even from the presentation of the evidence that the prosecution called that Mr. Beara was not seen ever in Srebrenica, and we can take a look at any of those videos. He was never seen in Potočari, and we have those videos as well. He was never seen at the Hotel Fontana at either the first, second, or third meeting. And certainly, he wasn't even seen at Mr. Zivanović's retirement party. It's significant for many reasons. The obvious one, he wasn't seen because he was not there. He physically was not in that area or territory during that time period. It's also significant because we believe that it shows what I referenced 2 years ago, a detachment, that Mr. Beara was not within a close-knit group and did not follow Mladić or others, and was excluded particularly from key and relevant situations. In fact, I believe our first witness today will testify about this detachment, and he'll give the court some background on it because keeping it in context is relevant and should be permitted. Before the VRS was formed, the court should understand where Mr. Beara was and who was his subordinate. For example, this next witness, we hope, will establish for the court that as late as 1990 and 1991, Mr. Zdravko Tolemir was a subordinate to Mr. Beara. When Mr. Tolemir goes to the VRS, and several months later, approximately 6, if I'm correct, Mr. Beara joins the VRS, and he becomes not a superior, or doesn't remain a superior to Mr. Tolemir. He becomes his subordinate, despite the fact that Mr. Tolemir is 9 to 10 years younger than Mr. Beara. And all of us who have studied any military code and know anything about rank can appreciate the significance of that evidence and the import that it has. And in our view, the relevance it has as to why Mr. Beara was indeed detached from General Mladić and others. Naturally, the VRS was a newly formed army, and it had numerous conflicts within itself, as well as the political parties and the pro-Serbian nationalists, both for power, position, and rank within their territory. The dislike or displeasure, lack of trust, and lack of cooperation, and quite candidly, the lack of relations, is perhaps best illustrated by the feelings, attitudes, and opinions that the civilians, including Dr. Karadzic, had for former JNA officers. The former JNA officers were not pro-Serb nationalists. The new political wave and the new political party seeking, as the prosecution alleges, a different makeup of Bosnia or Serbia or former Yugoslavia were indeed these pro-nationalists. Mr. Beara was politically, diametrically opposed to the politics that were being brewed in the area at that time. We have a witness and witnesses to help further establish that for the court. For example, Dr. Srđa Trivković, who the prosecution seems to suggest informally and maybe even formally that he may not be relevant. Here is also another American journalist of Serbian descent who was an advisor to Dr. Karadzic, not only in 1992 and 1993, he was in Pale in July of 1995. He was with Dr. Karadzic and the other civilian power brokers who were discussing and examining the facts as they unfolded in the territory. This also is quite candidly confirmed and corroborated by the witness whose diary we cited in the beginning of our discussion here today. He writes that he also met Dr. Srđa Trivković in Pale, that he discussed with them, and they know each other obviously from before because they are both journalists. I think Dr. Srđa Trivković, and I expect and believe that his testimony will enlighten us as to how diametrically opposed the civilian pro-Serb nationalists were when it came to specifically JNA staff security officers. There was not just, as I've mentioned, a dislike or displeasure. There was strong animosity and a strong distrust. We raised this point, and although this issue is on appeal, because the prosecution admitted evidence of a deceased individual without giving us the opportunity to cross-examine him, and the court, with all due respect, granted the evidence of a Miroslav Deronić, who, as we know, was a civilian within Bratunac in 1992 through 1995. It's incredible to suggest that Dr. Karadzic, being so diametrically opposed politically, having not only animosity but indeed hatred for security staff officers, that he would entrust and convey a secret message purportedly to kill Bosnian Muslim men in the Srebrenica area. It's not only illogical, it's unreasonable, and there is no basis for it whatsoever, despite the prosecution's attempt to give that testimony to the court through the deceased Mr. Deronić. On the other hand, we know that the civilian Mr. Deronić was very close to Dr. Karadzic. On that same notion, we find it incredible that indeed Mr. Karadzic or Dr. Karadzic would have used an intermediary, although he had direct access to Mr. Deronić, could have conveyed any such message if indeed that message was ever conveyed. We suggest that it was not, but just the inferences the prosecution is trying to suggest to this court and the way in which they speculate as to how things unfolded just do not have a sound basis in any of the facts or in logic. Other witnesses, such as Dr. Srđa Trivković, that we expect to call, will also further establish that there was this great hatred and animosity by the civilians, not only at the national level through Dr. Karadzic, but also at the local level in Bratunac through Mr. Deronić. Going back a little bit to the whereabouts of Mr. Beara, some of us may be thinking, what about the witnesses that the prosecution called and tried to lead evidence in that seemed to suggest, supposedly, that Mr. Beara was at a site where killings were being either about to happen or were already completed? We bring forth two specific categories of witnesses in this regard First, we bring to this court an expert witness, a psychologist here from the Netherlands who has, in my view, and I think the view of all of us in this courtroom, an excellent reputation. He's an expert who will share with us, and his name is Professor Wagner. He's an expert who will testify, and I think the issues are relevant to the purported whereabouts of Mr. Beara, and he will specifically address those witnesses that erroneously claimed they saw someone or described someone that the prosecution is alleging is Mr. Beara. At the end of the day, he will address with us through direct examination the flaws and weaknesses of such purported identification, premised on both recognition and identification. These two, although simple concepts, are quite distinct. One is, do you recognize someone you've met before? And the other category is identifying someone for the first time. We believe that through our cross-examination, we've raised enough doubt that those witnesses were incorrect and erroneous, that that was Mr. Beara who they claimed, or who the prosecution claims they have seen. Further, with Mr. Wagner, we believe that he will not only discuss how and why these witnesses are unreliable by looking at certain indicia of suspicion, he will also share with us the flaws caused and the failures committed by the Office of the Prosecution during its investigation by failing or refusing to properly conduct and show these witnesses a relatively simple and straightforward, objective photo board, as it's called, which is a group of pictures, as I'm sure we all know, of people who look similar or have similar characteristics. This photo board is actually a very, very important issue for both Professor Wagner, and it should be in this case. If the prosecution wants to stand by those witnesses, we must ask ourselves, why didn't they use a photo board? We'll hear from Professor Wagner that it is a very inexpensive and simple procedure, and that any investigator in the smallest of towns is familiar with it. But in this case, what's unique and special is that the prosecution did use a photo board in this case. The prosecution knows how to use a photo board. The prosecution selectively chose not to use a photo board in this case. But in two instances, they tried to do it. And my apologies to Mr. Popović and his counsel. One was of Mr. Popović, with the testimony of a witness who was an executioner at a site. They executed, the prosecution and counsel for Mr. Popović, a stipulation in that regard, and affixed to that stipulation is a 8-man photo board of 8 similarly looking individuals. And they asked this witness, who testified here, you mentioned that it was a lieutenant colonel and or colonel that you saw at the site. This witness was given a photo board, and he said, no, these people on this photo do not contain the individuals that on this photo board do not contain the individuals that I recall seeing at the site who were giving me orders to execute Bosnian Muslims. That same witness, however, was shown a prejudicial photo board of Mr. Beara. He was shown a picture with Mr. Beara in the center. The only, and excuse me, older individual within the picture, the only individual whose rank is clearly depicted and his stripes clearly depicted on his left breast. That photo board is what Dr. or Professor Wagner will tell you causes great prejudice. If that witness said that he saw a colonel or a lieutenant colonel, and you show him a picture with one individual, a colonel who should be older, and if you show him a picture with that individual's stripes and rank, it should be easy to detect who the individual is. We were fortunate enough that that witness also, as with Mr. Popović, he rejected that photo and said this is not affirmatively the witness or the person I saw at the killing site when I was executing Bosnian Muslims. That too is in a stipulation that we filed, and it's before the court. It's relevant because our expert will complete the story and show that the prosecution had the ability, but no interest, to do a photo board with all, not just some witnesses. Who was Ljubiša Beara? We've spent significant, or at least some time, discussing his whereabouts, and we'll get back to that for the other period. But who was he? During our evidence, we expect to show that Mr. Beara, throughout his professional career and his personal life, was a man who fostered and promoted multi-ethnic unity and tolerance. The evidence we expect to call will reveal that Mr. Beara, when possible, throughout his career, and specifically during the most difficult times during the war in former Yugoslavia from 1992 to 1995, helped, assisted, organized, and saved a large number of Jewish citizens from the former Yugoslavia. And when we say large number, it's my personal knowledge from speaking with this particular witness that he gives credit to Mr. Beara for saving, in his words, in the first time in the history of the world that the Jews were not persecuted or killed. And he believes, as being the head of that commission, that Mr. Beara is the individual who was not only instrumental, but it would not have been accomplished without Mr. Beara's assistance. The number, according to this witness, was approximately 1,500 Jewish citizens that Mr. Beara helped evacuate and helped save during the 1992 through 1995 period. We have evidence, and we'll bring forth the evidence, that Mr. Beara also helped Croatians as well as Macedonians during that war. We have evidence, and we expect to bring evidence to this court, if necessary with your assistance, that Mr. Beara throughout the war also assisted and helped Bosnian Muslims. He had, from time to time, both subordinates and colleagues who were Bosnian Muslims. Mr. Beara did indeed save some of these individuals from remaining in an area, even such as Bratunac. One witness in particular, his family was from Bratunac. Mr. Beara assisted his family and others that he did not know, meaning friends of this individual that he knew, that he helped save, to leave because Mr. Deronic and these civilians came in, and we know, because we've heard and seen the plea of Mr. Deronic as to what occurred in Bratunac at that time. Mr. Beara did help save those people. He couldn't save everyone, didn't save anyone, and by no question and never alleged he was not responsible to save anyone or everyone. We expect to present evidence that Mr. Beara did not and could not have the specific intent necessary for the crimes that are alleged against him. I will address that a little later, time permitting. My learned friend asked the question, was there a conspiracy then against Mr. Beara? Very, very difficult and complicated to prove. It is not our burden to prove whether there was a conspiracy. We bring forth the facts. But let me share with you one fact in particular, and that's a proofing note. On the 23rd of October, 2007, and I believe it may have an ERN number. I was unable to, a 65 turn number. I was unable to find it, but I do have the ERN number, and I'll just share it with the court so the record is complete. That is ERN number 06242-637. We think that examining that issue will shed further light as to how, when, and why certain individuals like Deronic and Dragan Mirković and others in the Bratunac area who were civilians had lied and fabricated evidence and stories. No doubt they had a motive. Crimes occurred before their very eyes, both in 1992 and in 1993. This document that I referenced and proofing note of the 23rd of October 2007 is also of a former local individual from that area. He was convicted and he pled guilty, but when he was proved and it was evidence that the prosecution sought to leave, my learned friend Julian Nichols, who I'm sorry he's not here, and I apologize for referencing him because he's not here, he conducted that interview. And with all due respect to him, I think he certainly has the qualities, or was a defense attorney, or has the qualities to be one. He records honestly in that proofing statement portions of that discussion with Mr. Nikolic. First, he tells us that the witness stated that he learned through information that, among others, Dragomir Vasic, Miodrag Josipović, and Dragan Mirković held a meeting at the Bratunac MUP headquarters after the killing. And I don't think we're in argument about this. This is discussing after the Kravica killing. Never mentions Mr. Beara. Mr. Beara was not there, did not participate in any such crimes that occurred there. Point 2 from the 23rd of October 2007 proofing note, same document. Mr. Nichols records that this witness also stated that, quote, Beara had nothing to do with the burial of the bodies at Glogova, end quote. Point 3, same document. Mr. Nichols records during those events, supposedly for several minutes or moments, while they were conducting the transfer of detainees, never before met him or had an encounter with him, and under any circumstances would not have accepted or discussed any of the matters that the prosecution has alleged that have occurred as it relates to Mr. Beara. They had their local military officers who they placed in power in their community. Military men they knew, military men that they supported, and military men perhaps whom they conspired with. The Bratunac civilian authorities did not need any outside influence to assist them in the transportation of civilians or Bosnian Muslims in 1995. Their strong-fisted or iron-fisted power and authority by specifically Deronic and Bratunac shows us that they did this very thing in 1992 and 1993. They were lost, the civilians in Bratunac, and were unaware how they should handle POWs. They were confused as to which sites can be utilized to hold and detain these individuals in 1995? Hardly, given that they experienced this very same thing, unfortunately, 2 or 3 years earlier. They needed no assistance, no consultation, coordination, or facilitation to detain these Bosnian Muslims from Ljubiša Beara. It is, indeed, we suggest, a conspiracy, and we will bring forth evidence of individuals who will help further define those civilians, specifically Mr. Deronic. We also will bring a Muslim witness, we hope, who will share with us what his views were of Mr. Deronic, but not from a civilian perspective, but from a military perspective. This young man was in the JNA, and he knew how Deronic, or what Deronic felt about JNA officers, how he treated them, and how he felt, Deronic that is, was above both the military and the law. Interestingly, the prosecution in its indictment also mentioned a relative, although I'm not sure if it's a first cousin, I think Nenad Deronic, who committed crimes during this area in the Bratunac vicinity. Of course he did. Any relative, friend, or family member of that power structure there had the green light to commit that, because Deronic was a strong-fisted power broker and allowed it to happen. Genocide. As with all the other counts in the indictment, including extermination, persecution, murder, etc., the OTP again alleges that Mr. Beara organized, coordinated, and facilitated the detention, transportation, and summary execution of these Bosnian Muslim men. I suggest to the court that they never answer the most simple and straightforward question. If you're going to make a claim that we've organized it, coordinated, and facilitated, inform us by whom were you so given such an order? When? Where? What was said to whom? They, during our 98 bis submissions, claimed that there was this order. They have no details to that claim. It's merely a speculative claim that Mladic passed an order to Mr. Beara. When? What was said? They're going to argue, well, certainly those types of things are not recorded. Certainly we've seen from witnesses and evidence such as Mr. Vasic, he plainly writes killings are occurring and we're structuring it and we're assisting in it in his July 1995 report. Their expert witness said that word killings doesn't mean really killings. It means something totally different. I suggest that the prosecution is selective in their prosecution, and I believe the evidence will help assist us in revealing that. You must also be wondering, but what about the intercepts? The intercepts seem to suggest, according to the prosecution, that there was only one man called Ljubiša, one man who has a nickname or is called Ljubo at that time. We are presenting evidence to help define who Ljubiša Beara was by presenting evidence of people who knew him before, during, and after the July 1995 period. And will confirm that indeed Mr. Beara had a rather distinct dialect formed from the Herzegovina and Croatia influences. One witness is an expert witness, Dr. Remetic. He's a linguist but also a specialist in dialects. He will help us, and I believe will opine, that after he read and analyzed the intercepts, after he met and evaluated Mr. Beara's speech pattern and current dialect and distinct speech, that the intercepts which merely mentioned Ljubo, or a derivative of that, without compromise to the identity, meaning it does not say that it was Ljubisha Beara on the other line, cannot and should not be attributed to Mr. Beara. Furthermore, Dr. and Professor Remetic will address the use of the term triage and how it has multiple meanings and in fact does exist, despite what the prosecution seems to suggest, in the military lexicon. We believe that evidence is critical and important because you've heard from the intercept operators. And despite our attempts at cross-examination with them to show that they've added or changed and in sometimes, in our view, respectfully manipulated those log books and intercept books, those intercept operators clearly said, we took down things verbatim. If someone spoke in a different dialect, we would record it and we wouldn't record it any other way. There's no evidence in those intercepts that that was the dialect that Mr. Beara uses now, used then, and used his entire life. Those speech patterns cannot be changed or altered. Those intercept operators should have, and would have quite candidly, wrote down the dialect Mr. Beara uses and used if he was the person who was involved in the intercept conversation. He was not, and therefore you do not see that anywhere throughout the intercept documentation that's been brought forth. We do also have additional witnesses in connection with the intercept, specifically an individual who will talk about how the wiring, and I'm just not certain if he's going to ask for protective measures, so I believe that he may, but he's going to show us how someone can call from a third place and get connected to Badam, who will then switch him and have a conversation with Zlatar. So this person calling from, let's say, Belgrade, calls Badam, and Badam connects him with the individuals at Zlatar. The way the prosecution sets their case, they put the person in Belgrade. They place him at Badam and say he was there because he has a conversation with Zlatar, and Zlatar is calling the Badam IKM or command. Untrue. That's not the way the communication system worked at that time, nor how it worked at any time. This witness will help flush out those issues for us, and we expect that his testimony will be quite relevant and will be rather revealing. Finally, on issues of genocide, extermination, persecution, recently the appellate court in the Nazir Orich case rendered its judgment. In that case, the Honorable Justice Schomburg had what I felt was a quite interesting quote from Sir Isaac Isaacs. And it is Sir Isaac Isaacs. I actually checked it twice. And I don't know it verbatim, but it really challenges your honors and us all to say that we can and should reevaluate legal and factual issues. And it's our opportunity to do so here. It's our duty to do that. We do not, and suggest that you won't, but to simply argue that genocide was found in the Krstić case or in the Blagojevich case is not sufficient. I think in those cases, with all due respect to them, the evidence that we've evaluated was in far greater detail. I think the evidence in those cases did not examine the anthropology or the archaeology or the pathology significance of these issues. And we invite the court to look at that, as I'm sure you have, and respectfully I'm suggesting it. Let's not persistently use precedent as a way to suggest that we are correct. Let's reevaluate the facts and the law and to determine, regardless of what those decisions said, whether or not there was indeed genocide that was committed here. We suggest, with the highest of respect to the victims and to the families and to the people of Bosnia that there was no genocide. There were tragic and horrific crimes that occurred, but there was no genocide in our view. We will present evidence, and one, I believe, although the court hasn't ruled, but has not drawn an objection from the prosecution through 92 bis, and that is the evidence of Dr. Chester Moore, an anthropologist. We also will call a forensic anthropologist to the stand, hopefully next week, Dr. Deborah Komar from Albuquerque, New Mexico. We believe that both, and specifically Dr. Komar, will address and discuss with this court the notion of minimum number of individuals, as referred to here, quote, MNI, end quote. She will also address some of the more salient and significant points where she believes that the anthropologists and archaeologists that the OTP called failed in their duty to properly maintain, record, and secure data and or relevant findings. Finally,
You've still got time.
thank you. I just wasn't sure, Your Honor. I saw you looking at me, and thank you.
Why shouldn't I be looking at you?
Well, it frightens me at times. But thank you, Your Honor. I didn't know if you were giving me a signal, so that's my only concern.
Go ahead.
Thank you, Mr. President. Finally, coupled with our evidence that we were going to bring in our case, and he was a joint witness, and my learned, esteemed colleague, Mr. Jivanovic, brought him. When we look at that anthropologist evidence, Dr. Komar and Dr. Moore, and we also take into consideration Dr. Dusan Dunic's evidence, which is our evidence as well, we can see that very important points were made, I believe, or at least we tried to make those points. And Dr. Dunic tried to explain it during his testimony when he tried to convey to the court, I believe, that if you're going to determine or render an opinion with respect to manner of death, you must in all instances know what the cause of death was. In no instance can you conclude what the manner of death is, homicide, if you do not know what the cause of death is. Dr. Dunic, as other experts, used this sample methodology, and he picked out several, I think it was 50, 52 examples of autopsy reports to suggest that it is not plausible, not reliable, that one can conclude a criminal act such as homicide occurred when they identify it under the category manner of death, when in fact, under cause of death, the pathologist would write unknown or undetermined. If you don't know how someone died, you certainly don't know why he died, whether it was a killing or by any other means. This sample methodology Dr. Dunic used revealed that in far too many instances, we had this undetermined cause of death, and that unrealistically, homicide was identified as the manner of death. In any event, we expect to thoroughly analyze these autopsy reports in order to further establish that many thousands died during what Richard Butler himself coined and identified, quote, legitimate military combat engagements, end quote. It is striking that in the autopsy reports, the OTP experts find no combat engagement or no legitimate military combat engagement death. Not one person. We believe that very fact causes not only suspicion, but renders their forensic pathologists and anthropologists' expert reports and opinions to be rendered unreliable. Further, I have been personally in contact with several Bosnian Muslims who were victims of crimes during the July 1992 period. Although difficult, I expect and hope that they continue to have the courage to speak with me and that they can honestly recollect for this trial chamber, consistent with the statements that they gave authorities when they ultimately reached Tuzla, consistent with the statements that they gave the Office of the Prosecution at times when they were interviewed. They define and describe for us that hundreds, thousands were killed in these legitimate military combat engagements. Further, and perhaps finally on the issue of genocide, the Honorable Alan Dershowitz, in discussing the Holocaust that occurred in Nazi Germany, describes genocide, and he's an esteemed colleague of ours because he practices before this tribunal. He describes the word genocide and says, there's no doubt that it happened in Germany by the Nazis. However, he says that the view that genocide occurred in Srebrenica is negated by the very evacuation, removal, or deportation, legal or illegal, of the women, children, and elderly men. His suggestion is, and we believe that in order for there to have been genocide or any genocidal intent, quote, the children had to be killed first because they were the genetic future. They are the genes. In this case, it is, we think, extremely significant that during the evacuation process in Potocari, Srebrenica, as well as in Žepa, the children, women, and men were indeed evacuated. We believe it was a result of military necessity. We believe it was military necessity because no one knew whether there was going to be resistance to the VRS during that time period. The VRS didn't even know what the reaction would be of the Bosnian Muslim military. They were quite surprised, as we've seen from videos, that there was no resistance. In fact, on the 11th, perhaps planned on the 10th, the Bosnian army of the 28th Division went to the woods in Shushnari. These are significant matters. The VRS had no knowledge that there would be no resistance. If there was any attempt or any suggestion of this genocidal intent, I believe that you'll find just from those facts that genocide did not occur, and that at the very least, Mr. Beara did not have genocidal intent, not only because of his absence or lack of presence in the area, given his complete and consistent professional attempts to try to save people of all ethnic backgrounds, that he did not participate or knew of such intent if it existed. And quite honestly, I suggest that it did not. Finally, I'm sure the prosecution wants to discuss the logbooks. Another piece of evidence that they seem to claim and have weaved into this, it's corroborative type of evidence. It's not corroborative. We will bring evidence to show this court, again, through a expert and fact witnesses, to show the court not only that there was a manipulation and an alteration of these medical records, of these logbooks, but that in fact there's great inconsistency if we look beyond just the dates highlighted by the prosecution. One of our experts in this case is the esteemed Professor Gogic. He's still in the process of examining and reviewing that. We have his preliminary report on this data, and we hope that when he lists out for us what the indicia or factors of suspicion are, and I think we as reasonable people can know that some of the factors are control and custody of the logbook. If it's maintained in a proper custodial fashion, you're not as suspicious. If one individual holds it, moves it, opens it, reviews it, pulls out pages from it, of course you should be suspicious. The next indicia of suspicion is, did anyone admit, or can we see evidence of post facto additions, even simple dates? Did anyone open the book and actually insert anything in the book? If they did, even in one instance, we suspect the document. The prosecution nonetheless says we admit that these dates were added, but that's all we're going to admit to here. These indicia of suspicion and things such as placement of entries, obliterated pages, ink colors are important, I think, for the court to read if you're going to rely at all on these logbooks. We think that the evidence, and I hope to call, because I've personally met with some witnesses that I am being challenged with now. I am having some difficulty, but I think it's important for the court to hear it, that in intercepts and in logbooks, people were adding individuals' names in order to shift blame and responsibility. That's not a defense. It's not, and it's not our defense, to suggest that others are culpable or to suggest that an empty chair may be responsible for the crimes that occurred, as they suggested in the Krstić or Blagojević case when it relates to Mr. Beara. That is not a defense. It never has been, and I'm sure it won't pass muster here. Finally, I want to discuss, if I may, pressure towards an accused, pressure from the prosecution, pressure even from his own lawyers to give the OTP something, anything, so that they may finalize the plea negotiations that were being discussed. How the prosecution asked, after years and months of this witness not mentioning Mr. Beara, all of a sudden, when there was something, consideration on the table, and pleas from the prosecution with fists slamming on the desk, pressure from his own counsel, this individual ultimately suggests and supposedly offers that, again, others were responsible. He acknowledges his culpability, not sufficiently in our view, but he also, in spreading his web of lies, also tries to encapsulate and include Mr. Beara. It will be difficult, and I know this, to bring this witness here. He said he'd come. He's very, very afraid. He's an honest man. He's a lawyer. He's a person who has worked at this tribunal for some time. We think that it is important for this tribunal to get the entire picture. Thank you. Your Honors and Mr. President, we expect that through this evidence, although I highlighted some, not all, of the evidence that we hope to bring forth, that you will respectfully find that indeed there is reasonable doubt on all the charges against Ljubiša Beara, and that the OTP has failed to meet its burden of proof as mandated. Thank you very much once again for the opportunity to address you.
Thank you, Mr. Stojic. We'll have a break now of 30 minutes because I have a meeting, and we'll start with the first witness immediately after. Thank you.
All rise. Forgive